Yeah, good morning, students. This is Sreekanth, Assistant Professor, Dr. Global Ambedkar Law Institute, Tirupati. Yes, signing in for company law. So, you know that company has to be registered with Registrar of Companies with two documents, important documents. One is Memorandum of Association, another is Articles of Association. Once if you submit these two documents, the Registrar of Companies will issue a certificate of incorporation, and from the date on which the certificate of incorporation has been mentioned, the company comes into legal existence. Once the company comes into legal existence, it has a separate legal entity separate from its members. Even one member holds the entire share capital of the company. Company does not belong to that shareholder. It belongs to whom? It belongs to stakeholders. Whoever is interested in the company, it belongs to all. That is the concept of separate legal entity. Separate legal entity separate from its members. Now, there is a classical case on which the concept of separate legal entity has been enunciated. The case law name is Solomon versus Solomon. This is the landmark case on which the basic premise of corporate legal entity or separate legal entity has come into existence. That means now the law recognizes as company and shareholders are not one and the same, they are different. Let's go into the classic case of Solomon versus Solomon. I am introducing the facts. Here, one person was there. His name is Mr. Solomon. Right? He was a shoe manufacturer and he has business in very sound condition. He was a single person manufacturing and doing shoe business. Now he wants to form a company. He formed a company named Solomon and Company Limited. Why? He wants to start a business now, a company, limited company. This company was formed by him for the purpose of taking over and carrying on his earlier business. So he wants to do business in the form of a company. So what happened is he transferred shoe manufacturing business to this Solomon and Company Limited. Now you know in a company there are members. The members of this new company were whom? Solomon himself, his wife, four sons, and a daughter. They are the members who? Solomon, his wife, four sons, and a daughter are the members, and members of the board of directors were Solomon and his two sons. Members Solomon, his wife, four sons, and a daughter. Board of directors were Solomon and his two sons. What Solomon did is he has transferred the shoe manufacturing company for rupees 40,000 to Solomon and Company Limited. Kindly see the technical aspect. He is doing shoe manufacturing business. He formed a company by name Solomon and Company Limited. He transferred shoe manufacturing business to Solomon and Company Limited for how much? 40,000. That means Solomon and Company Limited is purchasing what? Shoe manufacturing business. If you purchase some company, you have to pay purchase consideration. So Solomon and Company Limited has to pay rupees 40,000 to whom? Shoe manufacturing business. In payment of this consideration, Solomon took 20,000 shares of one each and debentures worth rupees 10,000. So what Solomon has taken as a purchase consideration? 20,000 shares of rupees one each and debentures worth rupees 10,000. in payment of this consideration. Debentures means it's a charge over assets of the company. Debentures imply that company owed 10,000 to Solomon, and for the repayment of this, a charge was created in his favor on the assets of the company, and one share was given to each remaining members of the Solomon's family. Now, purchase consideration has been fixed as rupees 40,000. Solomon has taken 20,000 shares worth rupees 20,000 shares, and debentures worth 10,000 shares. Now, debenture means it's a loan repayable by the company to the Solomon. Now what happens? Owing to trade depression, the company went into liquidation. So due to unable to run the business, company went into liquidation. Normally what happens is, if a company went into liquidation, it will be wound up by the order of the court. Then assets will be sold, liabilities will be settled. On winding up, the assets of the company were rupees 6,000 and the liabilities amounted to rupees 17,000. Here, assets is only 6,000 rupees and liabilities amounted to rupees 17,000. Now what happens is, you see, Solomon has taken debentures worth how much? 10,000 rupees. Debentures is a loan. So what happened? You are having only assets worth 6,000 rupees. Now Solomon has taken this 6,000 rupees in repayment of his loan worth debentures 10,000 rupees. After paying the amount of Solomon as secured creditor, nothing was left for unsecured creditors. Now, the unsecured creditors contended that company never had separate existence. It was in fact Solomon under another name. As such, he could not owe money to himself, and thus they should be paid first their credits, but the contention was rejected by the House of Lords, and it was held that Solomon and Company Limited was a real company fulfilling all the requirements of the legislature, and it had a separate legal entity from its members. So therefore Solomon was entitled to be paid his dues first as a secured creditor. It implies that once a company is registered, even though entire share capital is held by one member itself, company is different, the shareholders are different. Shareholders are, we can call shareholders as members also. So once a company is registered, there is an imaginary curtain drawn between the company and members. This implies that company is different and shareholders or members are different. Once the company is registered, it has a separate legal entity apart from its members. This is the classic case on which the separate legal entity has come into existence. You know that company has registered with register of companies. Once company has been registered, it acquires the status of a separate legal entity, and we have seen the Solomon versus Solomon case. Now there are different types of companies basing upon the nature of their operations. Different types of companies are operating in India. Nearly about 10 to 12 companies are operating in India. We will see how many types of companies are operating in India, and we will discuss certain important companies from the examination point of view. Let us venture into the different types of companies. Number one, chartered companies. Number two, statutory companies. Number three, registered companies. Number four, private companies. Number five, holding and subsidiary companies. Number six, public companies. 7. Government companies. 8. One person company. 9. Small companies. 10. Associate companies. These are the different types of companies operating in India. Let us go one by one in brief. First one is chartered companies. Charter means act. In England, we used to call act or statute as a charter. A chartered company is one which is incorporated under a special charter granted by the King or Queen of England. For example, East India Company, Bank of England, Standard Chartered Bank. These are known as chartered companies. The chartered companies are governed by the provisions of the special charter under which they are formed. The charter defines the nature and power of such companies. So, chartered company means a company which is forming under a special charter. Example, East India Company, Bank of England, Standard Chartered Bank, and so on and so forth. Coming to second company, it is statutory companies. A statutory company is one which is incorporated by a special act of the legislature. Here what happens is legislature will enact an act, and under this act of the parliament or state legislature a company will be created. So for example, Life Insurance Corporation of India, it was created by the Life Insurance Corporation Act. Food Corporation of India, created by the Food Corporation of India Act. The statutory companies are also known as corporations. These type of companies are generally created for the public utility services, and their main object is not to earn the profits but to serve the general public. So statutory company means they will enact an statute under which a company will be formed. Coming to third aspect, registered companies. A registered company is one which is formed and registered under the Companies Act 2013, and it also includes an existing company which was formed and registered under the Companies Act. You have to note that registered company comes into existence when it is registered under the Companies Act and certificate of incorporation is granted to it by the registrar of companies. Once if you register a company, these companies are governed by the provisions of the Companies Act 2013, rules, regulations laid down in the memorandum and articles of association. Normally, the registered companies again, they are subdivided into two types. One is limited companies and number two is unlimited companies. So, registered companies are of two types: limited companies, unlimited companies. Coming to private companies, now previously what happens is a private company means it has a minimum paid up capital of rupees 1 lakh, and this has been deleted by the Companies Act 2013. A private company is a company by which in its articles of association it will put four restrictive clauses. If you see the articles of association of a private company, you will find these four aspects, four clauses, CLAUSCS clauses. If these four clauses are present in any articles of association, it is a private company, and if these four clauses are absent in any articles of association, it is a public company. Let's go into what are these four clauses. One is restrict the right to transfer its shares. Private company cannot transfer their shares. Remember, if they want to transfer the shares, they have to transfer to its own members. Right. This is the first restriction. Second one is the maximum number of members in a private company cannot exclude 200. Only 200 members should be there in a private company. In a public company, unlimited. Third clause is prohibits any invitation to the public to subscribe for any shares or debentures of the company. Here, public cannot take any shares or debentures of a private company. And fourth restrictive clause is it prohibits any invitation or acceptance of deposits. Private company cannot accept deposits from the public. These are the four restrictive clauses that has been found in the articles of association. What are they? There is no right to transfer the shares. Maximum number of members is only 200. It cannot give invitation to shares or debentures, and the private company cannot accept any deposits from the public. So these are the provisions that has been contained in the articles of association of a private company. Now, coming to holding and subsidiary companies. Holding and subsidiary company. Let us go into the definition. Holding company is one which has controlled over another company, and that company over which the control is exercised is called as a subsidiary company. For example, a company A is there. Now, company A has formed company B company, and board of directors of the B company are provided by the A company. A is known as holding company and B is known as subsidiary company. A company is exercising control over B company. So A is known as holding company, B is known as subsidiary company. So how A is holding control over B company? First aspect is control over the composition of board of directors. A company controls the composition of board of directors of B company. In such a case, A company becomes the holding company and B company becomes a subsidiary company. So, board of directors of the B company is appointed by which company? A company. Second control is holding of majority of shares. Here, holding company holds majority of shares of the B company. The term majority of shares means more than half in nominal value of the equity share capital of the company. A company becomes a holding company if it holds more than 50% of the equity shares of another company. This is how holding and subsidiary companies comes into existence. Understand? Now coming to public company. Public company means again public company limited by shares. Public companies limited by guarantee. So here a public company is a company, and the articles of association of that public company do not contain the four restrictions, that is no restriction on transfer of shares, no maximum number of members, and no invitation to general public to subscribe for its shares. So if you remove the four restrictive classes that has been contained in the private company, that company becomes a public company. Very simple. If you want to know whether the company is a private company or public company, we have to take articles of association. And if you read the articles of association, and in the articles of association, if the four restrictive classes is there, it is known as a private company. If you remove these four restrictive clauses, it is known as a public company. This is the basic difference between public company and private company. Remember, Companies Act, Memorandum of Association, Articles of Association. Memorandum of Association, Articles of Association. These are the two basic documents any company will have. Now coming to next type of companies, government company. So government company means, the government is having control over those companies. A government company is one in which 51% or more of the paid up share capital is held by the central government, or by any one or more of state governments, or partly by central government, or partly by one or more state governments. So, paid up share capital. There are different types of share capital will be there. If the chapter comes, I will explain you in detail. For the sake of understanding, just remember more than 50, at least 51% or more than 51% of the paid up share capital is held by the central government or by any one or more state governments or partly by the central government or partly by one or more state governments. How much percentage? Now minimum 50%, 51% or more. The required percentage of this share capital, that is paid up share capital, may be equity share capital or preference share capital or both. The government can hold equity share capital or preference share capital or both. Even if the holding by the central or state government consists of only preference shares carrying no voting rights, the company will still be a government company. Subsidiary of a government company is also a government company. So in a government company, government holds how much of share capital? 51% or more of the paid up share capital. Now coming to one person company, one person company means only one person will be a member, and small companies, associate companies are that not that much important from examination point of view. Now we are having another type of company. It is known as foreign company. A foreign company is one which is incorporated outside India and having a place of business in India. You understand? Foreign company means a company which is incorporated outside India and having a place of business in India. So foreign company is one which is incorporated outside and it is having a place of business in India. So this is known as a foreign company. Let us recapitulate different types of companies. Chartered companies, example East India Company, Standard Chartered Bank, statutory companies, Life Insurance Corporation of India, registered companies, register of companies, private company, contains four restrictive clauses, holding and subsidiary company, controls the composition of directors as well as majority of shares, public companies, no restrictive four classes, government companies, not less than 51% or more of the paid up share capital is held by the governments. These are the different types of companies. From the examination point of view, you will get what is the meaning of government companies. So, a private company, I already told you, it contains four restrictive clauses. First one is it restricts the right to transfer its shares. Private company, remember, it cannot transfer its shares to outsiders. If it wants to transfer its shares, it has to transfer its shares to its members. This is the first restriction. Coming to second restriction, it limits the maximum number of its members to 200. Only 200 members should contain in a private company. That is the maximum limit. It cannot exceed 200. If it exceeds 200, automatically it becomes a public company. Third restriction is it prohibits any invitation to the public to subscribe for any shares or debentures. Simply, private company cannot issue shares or debentures to public. And fourth aspect is prohibits any invitation or acceptance of deposits. So private company cannot accept deposits. On the contrary, it is public company. Opposite to private company is public company. Public company can transfer its shares. Maximum number of members is unlimited. Public company can issue shares or debentures, and there is no prohibition on taking of deposits. It is known as private company. So you know that government company means 51% or more of the paid up share capital is held by the central government, by any one or more state governments, or partly by central government, or partly by the state governments. This paid up capital may be equity share capital or preference share capital. Whatever may be the type of the capital, the government should hold not less than 51%. For example, IOC, Indian Oil Corporation, is a government company. BHEL, Bharat Heavy Electricals Limited, is a government company. Then ONGC, Oil and Natural Gas Corporation, government company. Then Bharat Petroleum, government company. Bharat Electronics Limited, government company. Very simple. Government will hold not less than 51% or more of the paid up share capital. It is known as a government company. Vizag Steel Plant, government company. Recently, government wants to disinvest this company. That means they will sell their shares to private persons. So, these are the different types of government companies. Yes, students, this is Sreekanth signing off today. Have a good day.